Switching gears now, former President Trump's defense team is appealing a ruling from a Georgia judge that allowed Fulton County DA Fani Willis to stay on the election interference case. Quote, the court found that Willis's actions created an appearance of impropriety and an odor of mendacity that lingers in this case, but it nonetheless refused to dismiss the case or disqualify her. The court's order is ripe for pre-trial appellate review. Mark Smith is a constitutional attorney and a former member of President Trump's transition team, and he joins me now. Mark, does this motion filed yesterday have a shot? And if granted in Trump's favor, what happens next?
Yeah, because the case in Atlanta is not over, Todd, this means this is an interlocutory appeal, which are sometimes granted but often not. So, yes, I think this is a likelihood this is going to be granted, Todd, because the reality is this is an extraordinary case. The trial judge, Judge McAfee, specifically said that the law of Georgia dealing with the disqualification of district attorneys is a little vague and unclear. And he, I suspect, is going to agree with the Trump defense that it's appropriate for the Georgia Court of Appeals to step in and look at this to clarify the law. This is a very big case. Not only do you have the fates and the fortunes of the individual defendants at play here, you're also dealing with the potential future president of the United States, again, with Donald Trump. So this is a big deal. A lot of ambiguities associated with Georgia law. So I think that there's a good chance that the trial judge here, Scott McAfee, is going to grant this request, and that goes up to the Georgia Court of Appeals. And by the way, the Georgia Court of Appeals then has to also agree that the case should be heard now to clarify the law of disqualification of district attorneys.
So basically what this all means, the appeal and the process that it triggers all but assures that there's no way that this case is going to come to a decision by November 5th, Election Day.
I think there's no way that's going to happen either way. I mean, the amount of discovery and information and the exchange of documents is so voluminous, Todd, in this case, that I don't see how they could possibly get all the pretrial motions, the pretrial discovery, the review of the evidence, the dealing with experts. I don't see how they could get such a large and complex case with this amount of evidence, done in time to try the case by November. It just seems to me almost impossible physically to get that done, regardless of what happens with this request for an appeal to the Georgia Court of Appeals.
Sure. Law ain't fast. That's a fact. Meantime, former President Trump says he cannot secure a $454 million bond in his New York fraud case, and his attorney is calling it a practical impossibility. Quote, a bond requirement of this enormous magnitude, effectively requiring cash reserves approaching $1 billion, is unprecedented for a private company. So what happens next in this case? Does it get reduced, or is Donald Trump going to be forced to pay the full amount, potentially sell some real estate to do it?
Well, if the New York justice system is just, the right answer is that there should be no request for the posting of the bond of President Trump. Keep in mind, this is an extraordinary fraud case in the sense that in most fraud cases, Todd, you literally have a line of people out the door saying, my money was stolen and I want it back. That is simply not the case here. There's no victims. Even the banks that allegedly were the victims were perfectly fine with what happened here. So really, we're just talking about the New York Attorney General's request to get money. And again, it's not like New York needs money in that sense, or they were a fraud victim or anything like that. So it seems to me the right answer, if you're being just about it, is to reduce the amount of the bond required to be posted, to pause the enforcement of the judgment, or simply pause and not do it at all. Because again, you do not have a line of victims out the door that have to be paid off. So what's the rush in trying to collect money from President Trump? Keep in mind, there's no dispute that he's worth a huge amount of money, billions of dollars, because of his real estate holdings. But real estate holdings, as you know, Todd, are illiquid, and they're very hard to sort of sell and manage and whatnot. So that's why these banks are unlikely to want to borrow loan money against these illiquid assets, because, again, real estate doesn't move quickly. For anyone that's ever tried to sell our house understands that that is not a fast process.
And let's remember, our discussion just now centered on the New York state system. There's also the federal appeals process where he can invoke the Eighth Amendment, which, as a constitutional law scholar yourself, you know, prohibits excessive bail. This seems excessive. Mark Smith, thank you for your time. We appreciate it.
I'm Steve Doocy.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.